Hello, my name is Asli Sayar. I'm a licensed California and Nevada attorney. And on behalf of my own firm and my sister firm, Leah Law APC, welcome to another episode of Did You Know? And today we're going to retouch something we've discussed in a prior episode, and that is trusts and estate planning. And I wanted to discuss with you something many people don't know, is that a trust helps you avoid court when a loved one has passed away. Now, a lot of people don't know that. A lot of people think, well, I don't have a lot of assets, so it doesn't matter that I don't have a trust. Or people think, I have a will, I don't need a trust. But here's the thing, if you have anything other than a trust, if you have assets over a certain dollar amount, and that dollar amount is set by your state that you reside in, your family is going to have to take that will to court, especially in the states of Nevada and California, to say nothing of the other states in the union. So you want to avoid court. Court in general is not a speedy process. Court in general is not a cheap process. While there are lots of self-help and other resources available online, the court system, unfortunately, that we have in this country, while frankly the best in the world, is still not economically friendly for most people. Say a loved one has passed away and you have only a will. In California, you're looking at an 18-month case known as a probate case to sort out the assets of that loved one. And in the meantime, you don't necessarily have access to your loved one's bank accounts or assets to pay their bills, pay their mortgage, keep their business afloat if they have a business to their name. A trust helps you alleviate all of that. Think of a trust as sort of like a personal corporation. It's something that you have during your lifetime. You run your own trust. You can spend all your assets and do everything you like with your money, just as you would normally. But upon your incapacity or your passing, the trust designates a loved one or a trusted family member to take over in your absence, running your life, so to speak. And based on the written document that your attorney can help you prepare, such as myself or others in my firm, it sets forth what your loved one is supposed to do with your assets, who gets what property, how your business is supposed to be run. If you're incapacitated, it sets forth your wishes, that you want this particular family member or friend to speak for you and to make sure you're taken care of. Maybe you have specific wishes of, I want to remain in my home as long as possible, and I want the assets of my estate to be used during my lifetime to pay for in-home care or nurse, versus I be sent to a nursing facility. You need to put these decisions in writing, and the best vehicle to do that is a trust. A will cannot help you in terms of incapacity. A will only springs into action upon your passing and requires the court to help administer that will. So another very important reason to get a trust right now is a estate packet prepared by an attorney for you and your family, in addition to the healthcare directives we discussed in our prior video, is to create this trust. Trusts are not just for wealthy people. Trusts are for everyone who wants to make plans for their future and worst case scenarios and help their family avoid expensive court proceedings so that upon their passing, things happen smoothly, the transfer of assets happens quickly, and your wishes are carried out even if you cannot speak for yourself. So take the time and reach out to your attorney, whether it's myself or someone else, and begin the process of setting up a trust for you and your family. I hope this information proves helpful, and thank you for joining us for another episode of Did You Know?